Hello everyone, I Dr. Varun Kumar, faculty of MBA department from Tecnia Institute of Advanced Studies. Today I am going to deliver a lecture on duties of director. Firstly, we will discuss the definition of director. As per the section 2 of Company Act 2013, director means a director appointed to the board of a company. What are the responsibilities of director? We will discuss one by one. The board of directors of a company is primarily responsible for determining the company's strategic, objective and policies. Second one, monitoring progress towards achieving the objective and policies, and appointing senior management, and accounting for the company's activity to relevant parties like shareholders. Now we will discuss what are the minimum director required in a company. Minimum requirement of director of company depend on the type of company. Like first, one person company require one director, private company require two director, public company require minimum 3 director. Maximum 15 directors can be appointed in any format of company like OPC, public or private. Bypassing special resolution, company can increase the number of directors beyond 15. Out of appointed directors, one director should be resident in India for more than 182 days in previous calendar year. Major corporate disaster of recent times like Kingfisher, Sahara, Satyam, etc. has again and again proved the inability of Company Act 1956 to be ineffective in upholding corporate governance. Every time it is directors who are responsible in breaking shareholders' expectations and sometimes revealing the sentiments of stakeholders under a false veil of charisma. While using the corporate mechanism to fulfill personal welfare, to meet these challenges, Company Act 2013 has been enacted almost 50 years after the last amendment. It is built on the principle of responsibility of the board, protection of interest of the shareholders, self-regulation and openness through disclosures. The 2013 amendment has ensured several effective measures through clearly defining liabilities and responsibility of the directors and penal action on failure to follow the same. Now we will discuss one by one. A director must act in accordance with the article of association of the company. And next one is, a director must pursue the best interest of the stakeholder of the company in good faith and to promote the objects of the company. And next one is, a director shall use independent judgment in exercise his duties with due and reasonable care, skill and diligence. Next, a director should always be aware of conflict of interest situations and should try and avoid such conflict for the interest of the company. Next, before approving related party transactions, the director must ensure that adequate deliberation and held and such transactions are in interest of the company. Next one, to ensure vigil mechanism of the company and the users are not prejudicially affected on account of such use. Confidentiality of sensitive proprietary information, commercial secrets, technologies, unpublished price to be maintained and should not be disclosed unless approved by the board of or required by law. Next one, a director of a company shall not assign his office and any assignment so made shall be void. Next, if a director of the company contravenes the provision of this section, such director shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees. To ensure independence and equitableness of the board, the Company Act 2013 also cast various responsibility on the independent directors. An independent director is a member of the board of directors but doesn't own any share of the company nor does have any financial relationship with the company other the sitting fees it receives. As per Schedule 4 of the Company Act 2013, first, protecting and promoting interest of all the especially for minority stakeholders. Next, acting as a mediator in case of conflict interest amongst the stakeholders. Assistance in forwarding independent and equitable judgment to the board of directors. Adequate attention towards related party transactions. Honest and impartial reporting of any unethical behavior, violation of code of conduct or any suspected fraud in the company. Now we will discuss liability of directors. The liability of the directors can be both joint and collective for any and every act prejudicial to the interest of the company. Though the director and the company are separate entities, under the following cases the director may be held liable on behalf of the companies. First, tax liability. Unless a director or any past director can prove that the non-recovery or non-payment of taxes are attributable as gross neglect or breach of duty, then any present or past director will be liable to pay the shortfall in tax amount and any penalty associated. Next, refunding of share application or excess in share application money. Next, to pay for qualification shares. Next, civil liability in case of misstatement in prospectus. Next one, fraudulent activity, fraudulent business conduct and all associated debt and contract executed. Next, failure in making disclosure as stipulated SEBI regulations 1992 by the directors may attract legal proceedings by SEBI. Next, check bounced or dishonored. Under Negotiable Instrument Act 1881, signing of dishonored by director may lead to prosecution along with the company. And last but not the least, offences under Income Tax Act 1961. Now, last liability, last but not the least, offences under labour laws, specifically in case of Employees Provident Fund and Miscellaneous Provision Act 1952 and Factories Act 1948. I hope you understand the topic of duties of director. Thank you very much.